Okay, what is a deferred prosecution agreement?
It is an alternative measure to a full criminal prosecution, and where it became most popularly used is after the Enron scandal in the U.S. when Arthur Andersen, the consulting firm that was one of the big five consulting firms at the time, was criminally charged, and the company collapsed under the weight of those criminal charges. And there was a academic sentiment and a sentiment in the legal community that the collateral damage to the innocent employees and those in these companies, such as Arthur Andersen, that collapsed, that collateral damage was too significant, and they needed to find an alternative way to hold companies accountable, but not punish innocent employees, shareholders, pensioners.
Okay, why do we now have one in Canada?
Well, there's been discussion for some time, and the UK instituted a deferred prosecution model. They went a different direction than the US, and they included judicial oversight. So even if a prosecutor in a company has agreed on a deferred prosecution agreement, which would avoid a criminal prosecution, they require judicial oversight, and that's the model that Canada followed. I would say there are some suggesting that the DPA was rushed through into Canadian legislation, in part in response to the SNC-Lavalin case.
Okay, in response to the SNC-Lavalin. I'll get back to that in just a second, but what are the determining factors that allow a Canadian company to get one of these agreements as opposed to having to face a criminal trial?
Sure, well, it's set out in the enumerated factors, and they're not exhaustive, but they're set out in section 715 of the Criminal Code, and one of the first factors that the Kathleen Roussel, the Director of Public Prosecutions, would have looked at is the circumstances in which the facts of the case came to be, and came to be known to the authorities. And really what that section of the code is for is it's to promote self-disclosure. Companies should benefit from coming to the authorities when they discover wrongdoing within their company. Obviously, in this case, SNC did not pass on that test because the allegations came to the attention of the authorities through sharing of information from the Swiss authorities. Next, they'll look at the gravity of the offenses. And again, Kathleen Roussel, the independent prosecutor, would have looked at this case and seen massive bribery, like I said, in 40 million in a very difficult part of the world, dealing with a family, the Gaddafi family, known for their brutality. They also would have looked at whether or not the company had dealt with the individuals involved, whether they were willing to cooperate in the prosecution of those individuals. And I think in that case, SNC would have that would have been a factor in their favor. They did deal with the individuals involved. They did institute new compliance measures, new ethics rules. These are some of the other factors that the prosecutor would have looked at. They really would be focused, though, on the nature and the gravity of the offense, the period in which it took place. So in this case, SNC is not necessarily the best test case for the first DPA, because if you look at the US model or the UK model, companies that qualify often come in and self-disclose, so they bring information to the authorities that they wouldn't have otherwise had, so they benefit from that self-disclosure. And the companies can usually identify a few rogue individuals in a more shortened period of time in which the misconduct was taking place. For SNC, they would have had difficulty getting over those hurdles.
Okay, and one more thing about the agreement itself. They also would have to likely, as I understand it, pay a fine. That how are they held accountable that way? What's the pain to the company?
Sure. So the pain is there's a few items. There's the significant financial penalty, and you can see if you look at some of the bribery, the DPAs in the U.S., the significant fines paid into the hundreds of millions by companies. They also would have to have a monitor oversee their compliance program and the company for a period of time. And they would have to also admit the wrongdoing and cooperate with the authorities in the prosecution of the individuals. But the real stick is the financial penalty. And I should just say the other factor that the Crown Attorney would have been looking at is the impact on innocent employees and shareholders, which obviously also would favor SNC. So it would have been a balancing act of those factors that the prosecutor would have been looking at. But the real stick is the financial penalties associated with a deferred prosecution agreement.
Okay, you said that it doesn't look like they were the ideal test case for this DPA, but if the DPA was put into place by the Canadian government for SNC and yet it failed to make the grade, What does that tell you?
Well, in many ways, it was a misfire. I think the SNC was lobbying, and I think it was that's on the public record. There was op-eds. There was clearly the lobbying records show significant lobbying of senior members of the government to push for a DPA because they saw it as the only escape hatch from the criminal prosecution. And ultimately, the government passed the DPA legislation through a budget omnibus bill, which is unusual. But there it was on the books. But ultimately, we have safeguards in place to ensure that these kinds of steps are taken only when an independent prosecutor believes it's appropriate. And so I think it was not foreseen by the government that once it was on the books that the Director of Public Prosecutions would review it and find that it wasn't the right case for a DPA.
All right, Christopher, and here we are today.
Here we are.
Christopher Burkett, partner at Baker McKenzie and a former Crown prosecutor as well. We'll add that to the list of your titles. Chris, thank you so much.
Thanks, Carol.